Okay, we are back. I'm very happy to have here on the Goldstein on Gelt Show, Jeff Condon, who is an attorney who specializes in trusts and estates. Now, don't give up, because for a lot of people, trusts and estates are important, and that's why I brought him on the show. In fact, he is considered one of the top trust and estate attorneys in the country. The Wall Street Journal said that the book that he wrote with his late father is the best estate planning book in America. And of course, the book that we're referring to is called The Beyond the Grave, the Right and Wrong Way of Leaving Money to Your Children. So let's start with the wrong way. Jeff, what is the wrong way to leave money to your kids?
Wow, Doug, what a loaded question. What is the wrong way to leave money and property to your children and other heirs? Well, if you leave your children, let me put it this way. If you have an inheritance plan that treats your children unfairly, you have created a wrong inheritance plan. And that may sound easy to stay away from, because if you have 3 kids and you say, okay, Jeff, I have 3 kids, I'm going to leave everything to them equally, 1/3 each, what's the problem? Well, the problem is that you can inadvertently still treat your children unfairly, even though you may feel that you have treated them mathematically equal. For example, if you have 3 children and you only appoint one of them to carry out the inheritance instructions after you're gone, you have treated your children unfairly, because in their minds, to the children who have not been included, they will think, gee, mom and dad didn't love me as much, they didn't trust me as much, or they didn't think I was smart enough to do the job. So unless you have a compelling reason to not appoint all of your children as your after-death agents to carry out your inheritance plan, name all your kids.
Okay, let's talk about that a little bit, because I do have a good reason not to do that. No, I'm not talking about me personally, but in general. In my day job, Jeff, I'm a financial advisor. I sit in Israel and I work with people mostly who live here, but they have U.S. brokerage and IRA accounts and assets in the United States. And I've found, when unfortunately clients die, that it's easier to deal with just one executor rather than 3. And it just from and when things are easy, it's easier for the financial firms to deal with it, and therefore the orders get carried out quicker. Does this create a real problem?
It really depends on your school of thought, because Doug, the vein that you have talked about is that of efficiency. It's too many cooks spoil the broth. It's easier to deal with one. It's easier to get signatures of one of the after-death agents than to get all of them. So I absolutely see that point. But what people often fail to remember is that when they die, their children are no longer their children. They're just people dividing money. And when that happens, family loyalty goes out the window and it's a whole new ball game. And never more does this arise than in this power arena. It's not an unequal sharing of money, it's an unequal sharing of power. Because if that power is not shared equally, I promise you, you will have likely destroyed the relationships between your kids. So what I say is, yeah, efficiency is great, but at the cost of of family cohesiveness and togetherness. Sure, it may take an extra hassle. It may be an extra hassle to get signatures of everybody, but that can be alleviated by modern technology, by fax, by email, by what have you. So it may be it may take a little bit more time, and it may require some more effort, but ultimately, in my view at least, that effort is worth it in order to keep the family together and preserve family harmony.
This is very interesting. I'm very happy we're having this discussion, because oftentimes I tell people, your lawyer is going to tell you what to do, and I do not give legal advice because I'm a financial advisor, but I'll even bring in my office manager to the meeting because she's the one who actually handles the affairs after a client dies, and I'll say, tell me what you're thinking, and we'll tell you what actually has to be done, what the work is that the financial institution has to do after someone dies, because the lawyers are the ones who do it before you die and make the plan. So it's just interesting, I think, our discussion to see that there really are different ways of looking at it. One of them is what's the most convenient, and one of them is maybe what's the most legally correct way to do it. Jeff, tell me, what's the problem if one kid has more power if he divides the money equally?
When you name that one child as that after-death agent, in the United States, that person is called the successor trustee, the one who is charged with carrying out the instructions. When you give that child, that one out of three, or even 2 out of 3, or 2 out of 4, you are giving those in-power children a lot of power, because those children have the power to decide what attorneys are going to be used, what accountants will be used, when will the distribution of the inheritance take place, and what each share of the inheritance will be. Because if you have 3 kids, the successor trustee has the power to determine what each of their shares will be. So that successor trustee can say, okay, as long as it's roughly equal, I will take the real property and you two can have the stocks. And it's all equal, but those other kids may not like that. They may want an equity position in the real estate. So and that child has the power to decide what assets will be sold to pay the estate tax, or what administration expenses are necessary or not necessary. I could go on. But the fact is, there is a lot of decision-making authority that is in the hands of the few. And if the others are not happy with those decisions, I promise you that they will put pressure on that child to the extent of even filing a lawsuit against their power sibling to prevent him or her from making various decisions.
Wow. I haven't seen that yet, but I certainly in my own practice, but I have heard about that. We're talking with attorney Jeff Condon, who wrote the book Beyond the Grave, The Right and Wrong Way of Leaving Money to Your Children. Jeff gave us one very interesting fact, which was kind of a different way of looking at it from how I've always looked at it, regarding who to set up as the executor or the successor trustee in your estate. And Jeff, let's switch gears a little bit. One of the issues that a lot of people say, thank God I don't have to worry about anymore, is estate tax. People who aren't worth $5 or $10 million as a couple. But are there tax issues that people need to worry about in setting up their estates?
Absolutely, Doug. And this is something that I deal with my practice on a daily basis. I don't want to get too technical, but it's likely that a lot of people who are listening now have a living trust. And in this living trust, with married couples living trust, there will be a provision in there which says that when the first spouse dies, the trust estate, the assets in the trust bucket, split into 2 separate subtrusts. One of the subtrusts is owned by the surviving spouse. That half goes into the surviving spouse's trust. The other half goes into what we call the B trust, or a bypass trust, or an exemption trust. Whatever it's called, the purpose is the same. The purpose of that B trust is to preserve the estate tax exemption amount of the first spouse to die. Why is that good? So that when the last spouse dies, the assets in that B trust will not be counted in that surviving spouse's taxable estate. The result is that there will be no estate tax when the surviving spouse dies. Now, that's a good thing, and that's just fine. However, the laws in the United States have changed where you don't need to do that trust split anymore. You don't have to do it. Why? Because the rule is that everybody has a exemption amount of $5.45 million. So if the surviving spouse alone has an estate of less than $5.45 million, we don't need to preserve dad's exemption amount with the B trust. And that's great. And that makes life a lot easier, because these B trusts sometimes are a pain in the butt to set up and to maintain for the rest of the surviving spouse's life. It's a pain. But here's the deal. If these trusts still say you got to set up a B trust, then they still have to set up a B trust even if they don't need one. So
what you're saying is that people who did this a while ago when it was a popular way of setting it up actually have to revisit their trusts and perhaps rewrite them?
Absolutely. They have to visit their estate planning attorney. Husbands and wives who are listening to this, who have a living trust, a joint living trust, they have to see their lawyers soon so they can say, instead of making this trust split mandatory, we want to make it optional because, laws change. Maybe we'll go back to an exemption amount that's super low, like $1 million like it was a number of years ago. So we should at least have the option. The surviving spouse should have the option of splitting the trust estate into the survivor's trust and the exemption trust. But if it's mandatory, then they say, Mr. Condon, do we still have to do this? The surviving spouse after the first spouse dies, and I'll say, yeah, kind of, but we don't have to do it. I know, but we still have to do it, right? Because that's what the trust says. I have actually had to go to court after the death of the first spouse to get the judge to sign an order amending the trust in order to show that the surviving spouse does not have to do the mandatory trust split. And that cost
it would have been
a lot of money. So go to your...
Would have been much easier if they just dealt with it while everyone was still alive and straightened up the trust in the document. A living trust, like you're describing, is a great document for a lot of people, but I think it's important that everyone from time to time, and according to what you're saying now, Jeff, people have to take the time and review it because things do change and they really have to make sure they're up to date. One of the things, Jeff, unfortunately, is that we are up to the end of our time here, but I know that there's a lot more information that you have to share with people about handling their estates. Tell me in the last few seconds, what's the best way for people to learn about what you do and to keep track of what you're doing?
Well, Doug, thank you so much for this opportunity. I have written 2 books on estate planning, inheritance planning. One of them is the best-selling inheritance planning book in American publishing history. As you mentioned at the beginning, Doug, it's called Beyond the Grave. The subtitle is The Right Way and the Wrong Way of Leaving Money to Your Children and Others. And I am proud that the Wall Street Journal called it the best estate planning book in America at one point. And the other book, which came out in January of 2016, so it's still relatively new, is called The Living Trust Advisor. Everything you and your financial planner need to know about your living trust. And you can look up both, and people can look up both those books on Amazon, of course, and on any other book-selling website. My personal website is www.condonandcondon.net. That's CONDONANDCONDON.net. And if people want, they can ask me questions. I do not charge to answer brief questions over the phone or by email. And I invite people to take advantage of the opportunity to talk to a lawyer for free. There's no catch. I know it's hard to believe, but there's no catch. And Doug, I just want to say that I think that your show is excellent. This is not puffing you up. This is not buttering you up. I've got the gig. But I've looked at your YouTube site, and I've really found your interviews terrific. You're a really good interviewer. And also, I think the name Goldstein on Gelt is probably the cutest name for a show I've ever... and I've been on a lot of shows. I've been on all kinds of shows. That's terrific. It's real Borscht Belt. And I love Borscht Belt humor. So, job on that, Doug.
All right, I really appreciate that. Jeff Condon, thanks so much for taking the time. We'll put links to all of that at the show notes of today's show at goldsteinongelt.com. Thanks again.
Thank you.
You've been listening to the Goldstein on Gelt Show with money maven Doug Goldstein. Doug's weekly radio show is heard around the world, but if you miss it, you can download the podcast at www.goldsteinongelt.com. The Goldstein on Gelt Show gives you up-to-date financial ideas so you can get on the path to financial freedom. If you'd like your questions answered on the air or off, send Doug an email to doug@profile-financial.com. It's your money for your future, so join Doug every week to build your wealth on the Goldstein on Gelt Show.